In the last video, I discussed how Death Knight would likely be seen in the eyes of the criminal law of Stormwind. I also mentioned this would be a two-part video, with the next part exploring some of the impact in the civil law. If you haven't seen the first video, click here to watch it. As we know, the actions of third-generation Acaris Death Knights are excused by proclamation from King Rin. But what is the reach of Rin's proclamation? Alright, let's begin. Though I explained in the previous part, I'll quickly go over it again for context. The civil law is, generally, the name given to the areas of law that encompass transactions and interactions between individuals or companies. It is distinct from criminal law in that all the proceedings under criminal law, there are punitive measures at stake, either fines or jail time. In the civil law, however, it is more focused on a traditional, equitable view of justice. Basically, what is the most fair for all parties involved. Civil law is also much bigger than the criminal law, in that there are many more areas of law that make it up than in criminal law. In order for someone to become a Death Knight, they first need to die and then be resurrected. For the purposes of the civil law, the death is the most important part. There is absolutely no guarantee that a Death Knight would break free of the Lich King to return to a life in the Alliance. The question then becomes when a Death Knight can be considered dead for the purposes of the civil law. Since there's no direct analogue in the real world that we can draw from to form our conclusions, we simply have to use what little we have that remotely resembles this scenario to uncover how it might work. A person will be considered legally dead when they die, obviously, but if instead someone goes missing, as may be the case of a Death Knight, most jurisdictions stipulate that anyone who wishes to receive a grant of probate and execute a will must wait a certain period of time and then seek an order from the court that states that the person whose will it is can be considered dead. Only then can they admit that will to probate. In Stormwind's jurisdiction, we can only guess as to how this might work. It might be an arbitrary number, 7 years for example, as it is in some jurisdictions in real life, or there might be a specific provision in the law about undeath, since undeath is not entirely uncommon in Azeroth. In either case, we can make an assumption that the law provides that the affairs of a person who dies and goes missing, or is raised as a Death Knight, cannot be executed via will for a period of time, we'll say 2 years. This would give the missing or resurrected person a chance to either come back or break the Lich King's hold without losing out on their estate. When a person dies intestate, they are said to have died without a will. When they die testate, they have died with a will. According to the feudal law of the time, an intestate person who dies without heirs instead has real property escheated back to the crown, which in this case would likely be Stormwind. Real property refers to land, basically, that's all that real property is. However, when they die testate, meaning they have a will in place, the executor of their last will can apply to the court for a grant of probate on that will. This means that they are able to begin the execution of the will and handle the affairs of the deceased. This is generally the way wills are executed, but if people want to contest the validity of the will, or if there are multiple wills in question, there are a whole other range of issues that I won't go into here. So as soon as a will is admitted to probate, the executor takes legal title to the property in the estate. This includes everything from real property, land, or chattels and money. They're then distributed according to the terms of the will. So if a person comes back from the dead as a Death Knight and wants some of their stuff back, they don't seem to have many options. There may be certain principles of equity that developed in Stormwind to help counteract this. For example, a person who receives a substantial portion of an estate may be required to provide for the resurrected person if they come back. Through my research, I haven't found any authority or evidence of a similar principle of equity. In the case of Stormwind, it is possible that a court would want to adopt a principle like this as to not disadvantage a risen person, but I can't even begin to guess at how likely that might be. Failing that, there is one way a person could keep some of their assets to themselves. It only works for people who die testate. In their will, they could add what is known as a condition subsequent gift. The condition would read something like, I give my house to my son, only if I do not get resurrected and doomed to live in undeath. The way this operates is simple. The son in that case would be granted the interest in the land so long as the father does not get resurrected. If the father did get resurrected, the gift would then revert back to the estate and likely the father then taking back interest and ownership of the land for him to live in. Since we don't really have anything to compare these issues to in life, we can only guess at how it would resolve. It's pretty likely that the fear of undeath and its prevalence when fighting certain combatants like the Scourge would cause many people, particularly soldiers, to put conditions subsequent on gifts in their will. In a similar section of estates, people who have a right to pursue a lawsuit, for example, a breach of contract suit or an action in tort, when they were alive, but subsequently die, still have a right to pursue that claim when they are dead. In real life, obviously, dead people can't sue other people, but it instead falls into the estate and the executor or power of attorney for that person can pursue the claim on their behalf. Similar to a possible equitable principle I just discussed before, A person raised into undeath who comes back to the jurisdiction in which they have a claim may be granted full access to the claim and any award and damages it gives, so long as they meet the other requirements like mental competence. Again, we can't really be sure at how this would unfold, but that is one possible scenario on how it might. Moving a bit away from wills and estates, there are other issues in contract that a death brings about. Most contracts with an individual will terminate when that individual dies. This is particularly true with a life insurance policy. In a life insurance contract, the death of the individual makes up the performance of the policy. This means that, obviously, upon death, the insurance company is now obligated to pay out the claim as stipulated on the policy, but a person being resurrected would not void the initial contract. This is because the life insurance contract stipulates that death, as well as making the required payments, are the only things that the individual must do in order to force the insurance company to fulfill their obligation to pay out the claim. So long as there is no other stipulation in the contract that a person must remain dead after their initial death, the insurance company cannot seek a claim in breach. Basically and generally, a resurrection of someone who received a life insurance policy will still be able to have their family receive the money, no matter what happens after the grave. A marriage is also a contract that lasts until death. Upon the legal death of someone who is married, their marriage terminates. If they are resurrected as a death knight, they and their former spouse will be considered legally single, unless they go back to the former partner to get remarried. The final area I will refer to is that of tort. Tort law is the area that most people think of when they think of civil law. It's the area where the individual wrongs are addressed. A person suing someone for hitting them, or for spilling a hot coffee on themselves and suffering damage, is normally suing under tort. The standards are very different from criminal law when it comes to a claim in tort. For example, in the criminal law video, I talked about a death knight being acquitted of charges with a defense known as automatism. Though this defense applies in criminal law, it may not work in civil law, as the state of mind of the defendant is irrelevant in civil law. Normally, an involuntary reaction will serve as a defense to a claim in tort, but since it is not equitably just for a family to receive no compensation for losing a family member to a death knight, it may happen that judges are instructed by legislation not to accept this defense when issued on behalf of death knights. The reason legislation might come out that states this is that the Crown of Stormwind recognizes that inducting death knights back into the Alliance would be unpopular, and public policy always reflects the cultural attitudes at the time. It might also be possible that the residuary estate of a death knight could be sued by a family in tort to gain some form of recompense after their family member has died. Though the death knight could not control their actions, it may simply be allowed under a special form of tort admitted under common law, where limited damages are paid from either the individual knight or the estate, so that families who lose loved ones are not without a cause of action to alleviate their suffering somewhat. As we see sometimes in real life, the Crown of Stormwind may set up a fund for victims of death knight atrocities. Instead of allowing death knights to be sued over actions they had no choice in, it's possible that the Crown will pay out of this fund to the victims or their families of death knight attacks in order to appease the general populace, while still maintaining the public policy stance that death knight actions will be forgiven, but not forgotten. This has been the second in a two-part series on how Alliance Death Knights might have been affected by the areas of law in the capital of the Alliance when they return after having broken free. For the final time, there is no way I could actually say with 100% certainty how these scenarios would have unfolded in their circumstances. Instead, I can only guess at it with my knowledge of the law as a law student with a keen interest in world-building fictional legal systems. If you enjoyed these two videos, please leave a like and a subscribe, as I'll be doing more legal videos like this in the future. Also give me a comment on what you enjoyed or didn't enjoy, and I'll take these into consideration for the future. Thanks for watching, stay tuned, and I'll see you in the next video.